Hi everybody, it's Mike Kennedy, Vermont Bar Council. Welcome back to the garage for another presentation on professional responsibility and legal ethics. I've been doing them from the garage while I'm at home during the coronavirus public health crisis. On that, I hope everybody's staying safe, staying healthy, staying home, being good to each other and good to yourselves. I just got back from a run, did my first ever virtual race today. Half marathon, and half marathon is long enough to start thinking about things other than how far you're running. And there was time today during the run where I thought I need to do some more outreach on how to practice during the pandemic and how the pandemic affects, if at all, a lawyer's duties under the rules of professional conduct. I'm trying not to laugh right now because there's a group of kids out there that live in the neighborhood who I think are going to start heckling me. They are mad that I won't go shoot hoops with them right now. I told them that's not the best idea these days. They're mad, A, that I won't go shoot hoops with them. They're also mad that what I said, as far as not being a bad idea, is exactly what their parents have told them. And they don't like when I tell them the same things that their parents tell them. So anyway, I'm trying to not let them get me. I got heckled a lot when I was coaching basketball, well-deserved heckles. I've never been heckled given this presentation on legal ethics and professional responsibility before. I'm using my notes on my phone so I can stay sort of focused instead of rambling like I tend to do. So anyway, when the governor issued his stay home, stay safe order, a lot of lawyers contacted me. Curious. That was my mom yelling to me. She doesn't realize that I'm actually giving a presentation right now. My mom lives in my neighborhood and she's out for a walk. She's doing a good job. She just kept going out, but that was her screaming to get my attention and she got it. Anyway, when the governor issued his stay home, stay safe order, a lot of lawyers contacted me. Lawyers perceive a tension between their duties under the order as citizens and their duties under the rules of professional conduct. Now, call me with your individual questions. Each of you has very different situations, different client bases, different issues that you're facing at work. And I'll talk you through them, share my thoughts. Here's the big picture. And the big picture is that there's a big picture, okay? The rules of professional conduct, it says right in them, are rules of reason. It says in the preamble, in my opinion, it is not unreasonable for a lawyer to conduct a lawyer's practice during a public health crisis in such a way as to minimize the risk of acquiring or spreading a deadly virus. Let that idea influence everything that you do in your practice going forward. And it really influences everything I'm about to talk about today. So first, I want to talk about the duties of competence and communication. To me, competence includes understanding the effect that current events have on your client, on your practice and your client's matters. So for instance, on March 16th, the Supreme Court of Vermont declared a judicial emergency. It's Administrative Order 49. Since then, the court has amended the order several times. On March 13th, the governor issued the first executive order related to the coronavirus pandemic. He's updated it several times, several addendums, one of which came out last week with the stay home, stay safe order. And of course, as many of you know, the various superior courts in Vermont have issued orders in response to both the governor's order and the Supreme Court's order declaring a judicial emergency. The local orders affect how court operations will proceed for the duration of the crisis. To me, competence includes understanding how the various judicial and executive orders and their amendments and addendums affect your practice and affect your client's matters. So I think you have to stay abreast of them going forward until this is over. I think you also have a duty to communicate to your clients how the various orders are going to impact their matters. Let them know. Many of you probably already have. You've probably already heard from your clients, but I think that the duty to communicate with your client, which I'm going to talk about a little bit more in a minute, includes right now letting them know how their matter will be impacted by the fact that the courts are essentially only hearing emergency matters right now. Speaking of emergency matters, something I didn't know until I looked at the rule last week. And so generally, Rule 1.1, the rule that requires competence, it says that a lawyer must have the skill and knowledge necessary for the representation. There's a comment to the rule, though. It's comment 3, and I found it interesting given what we're going through. It says that in an emergency, a lawyer may give emergency advice and assistance in a matter in which the lawyer does not have the skill ordinarily required for the representation. Now, I'm not advising lawyers to start running out and giving advice in matters that they know nothing about. However, if it's an emergency and somebody has contacted you for emergency advice, you can help them without having to worry about an ethical violation. The comment does, however, go on to say that even in an emergency, assistance should be limited to that reasonably necessary in the circumstances. And I'm going to talk about reasonableness in a moment. It goes on to say, for ill-considered action, even under emergency conditions, can jeopardize the client's interests and rights. So yes, you can provide help in an emergency, but make sure it's an emergency, and then try to stick to just the whatever is reasonably necessary to get the client through that moment, that circumstance. Okay, moving on to diligence in communication. Those are rules 1.3 and 1.4. Rule 1.3 requires lawyers to act, quote, with reasonable diligence and promptness, unquote, on behalf of their clients. You'll know in a minute why I'm using the quotes, the air quotes. Rule 1.4 requires lawyers to keep clients reasonably updated as to the status of their matters and to respond to clients' reasonable requests for information about their matters. Now, in my opinion, reasonableness, reasonable, when it comes to assessing what's reasonable right now, context matters. We are in the middle of a crisis. So to me, what's reasonable now is quite different than what would have been considered reasonable last summer or will be considered reasonable once we get out of all of this. So remember, we are in a public health crisis. You can prioritize when it comes to diligence the cases that need to be worked on. You can prioritize it. Communication might be hard with your clients right now. Prioritize that. Understand that reasonableness necessarily depends on the bigger picture. Okay, that's my position. Moving on. Okay, not a happy topic, but what if you as a lawyer become unavailable because of, say, isolation or quarantine, or if you get so sick that you simply couldn't communicate with not only your clients, but even some of your family members. What's going to happen if you're unavailable? Do you have a plan? So Rule 1.3, the rule that requires diligence, suggests in a comment that solo practitioners, small firms, should have succession plans. I've blogged that large firms should have them too, usually not a succession plan, but more a disaster plan. What's going to happen in a disaster? And we're in a disaster. So it's a good reminder that right now, especially people working in the smaller firms or on your own, there should be some backup in case something happens to you. For instance, if you are unable to communicate with your clients, who's going to contact them to let them know? Who's going to let the courts and opposing counsel know? Who will deliver files? Who will return unearned funds? Who's going to check your calendar, your voicemail, your email? Who will handle any emergency hearings that are going forward that you miss because you become unavailable? Those are some things I think you should be thinking about. If you have a plan, this is key. Make sure somebody knows what it is and where it is and what triggers it. I went to a seminar on succession planning when I was on the VBA board. And because the VBA board was coming up with its own succession plan a couple of years ago. And the person who led the seminar said, the biggest problem with succession plans is not that people fail to adopt them, it's that when they do, they don't remember where they put it or tell anybody where they put it, or if they even have one. So if you adopt a plan Make sure somebody knows where it is. Make sure the person who is going to help as your backup knows that they are helping as your backup. Make sure somebody knows what triggers it. Related to what if you become unavailable, remember, that's sort of like an extreme case. There's a whole spectrum of wellness. At the far end is you're just unavailable. You're too sick to be able to communicate with your clients. Before that, take care of yourselves too. Remember, you can't take care of your clients unless you take care of yourself first. And right now it's very stressful times. There's a lot of anxiety out there just associated with life, not to mention having to manage a practice. I put up some resources on my blog for lawyers to cope with stress and anxiety related to the pandemic. One of those resources is one I recommend. It's called the Lawyer Depression Project. It's a project that was started last year, and it's for lawyers simply to go online and chat with other lawyers. You don't have to have a diagnosis of depression to participate. It's just for anybody who is stressed, anxious about what's going on, and wants to just share some thoughts, communicate with other lawyers. I especially recommend it for those of you who are isolated right now and don't have somebody else to chat with. Okay. Your clients aren't immune either. So remember, Rule 1.2a, it gives to the client control of the objectives of the representation. If your client is unable to communicate with you, what are you going to do? Now, for some of you, this is not a concern at all. For others of you, you may have clients who are susceptible to becoming sick and not being able to communicate with you. With clients like that, it might make sense right now, especially if you have some critical decision points coming up in their matters, to get some advanced direction. That way, at least you will know or have some idea of what the client wanted to do when that point arrives. Just a thought. And going back for your, I need to go back and include this because there's a little surprise at the end. If I don't include this, the surprise will kind of be ruined. But when it comes to planning, succession planning, I'm not immune. And so last week the PRB met, and I recommended to the PRB that it come up with a plan for who's going to cover for me if I'm, hospitalized and can't respond to inquiries, screen complaints, keep doing updates from my garage. Now, I haven't shown a symptom. I feel great, just ran that half marathon this morning. So the entire time I was making that recommendation to the board, and as I say it again right now, I am that Amy Stewart song, knock, knock, knock on wood. I am knock, knock, knocking on wood. But it just goes to highlight, everybody's got a plan because none of us are immune. Okay, getting back to wherever I was. Client confidences when you're working remotely. Most of us are working remotely right now. Don't forget, you have a duty under Rule 1.1 and 1.6 to act competently to safeguard client information. That includes, or it means, you have to take reasonable precautions to protect against the inadvertent disclosure of and the unauthorized access to client data information relating to the representation of the client. So if you're working remotely, that might include, I hope you're not using public Wi-Fi. Some of you may share Wi-Fi with a neighbor. I don't. But I was approached once by a neighbor who we wanted to chip in and share the same Wi-Fi service. If you're doing that, think twice. Should you have a VPN set up right now? That it might be worth considering. But just remember that there are risks associated with working remotely when it comes to protecting client data. And it's not just the electronic risks. Do you have a dedicated workspace in your house? There's no exception to the rule against disclosing client information for, my kid happened to hear me talking to the client who I had on speakerphone, or, yeah, I left the files laying all around the living room and my spouse read through them. There are no exceptions for that. So another little tip, a dedicated workspace at home. Trust accounting questions have been coming in, mostly around the same issue. We do not in Vermont require a wet signature, an actual signature on trust account checks. So you can delegate to someone who actually may be in the office the authority to use your signature stamp if you have one. You can do an e-signature on electronic checks. Just remember, whatever authority you delegate, you're still liable if something goes wrong. So be careful, trust whoever you delegate to. Last, civility and cooperation. I think civility always matters. It's one of the 7 C's of ethics, in my opinion. We need it more now than we ever have. My first blog in response to the crisis was a couple weeks ago, and I urged lawyers to be reasonable with other lawyers when it comes to requests to extend deadlines or to postpone things until we can do them safely again. I'm sticking by that. I've not heard any real horror stories from Vermont. I heard one that really disappointed me, but I've read some horror stories from other states, lawyers who have just been utterly unreasonable about extending deadlines, postponing in-person events, filing things in court that are simply not emergencies. I've blogged about them. One actually resulted in lawyers shouldn't have accessed the courts on this particular issue right now, but the court order that resulted from it made me laugh. It was the funniest court order I've ever read. Check it out, it's on my blog under the headline. I think it's called Ripeness and What Not to File During a Pandemic. But remember, be reasonable, okay? If somebody needs an extension right now because of what's going on, give them the extension. The courts have extended many of the discovery deadlines. Check out the standing orders issued by the superior courts. We got to work together right now until we get through this. I think that might be it. Again, if you have any questions, let me know. Here's a good quote I had, Judge Amy Tottenberg. She's a United States District Judge in Georgia, and on my last point, she issued a standing order that applies to all matters in her court that says, it includes this phrase, this sentence: be kind to one another in this most stressful of times. Remember to maintain your perspective about legal disputes, given the larger life challenges now besetting our communities and world. Good luck to one and all. So to get back to what I said at the beginning, that says keep the bigger picture in mind. The rules of professional conduct are rules of reason. It is not unreasonable to conduct yourself as a lawyer right now in such a way as to get in line with what we're doing in society, and we're minimizing and stopping the spread and acquisition of a deadly virus. Thanks very much. Thank you for listening. I hope it was helpful. Email me. Now, I'm going to do one thing here. Some of you might need proof that you actually watch this. That right there is a link to a little quiz. It's either 9 or 10 questions that covers everything I just talked about. I'm going to leave it on the screen right now so you can take it down, or write it down, whatever. Screenshot it. Just lost track of what I was going to say. Oh, it requires an email to take the quiz, and I will see your email. The answers will come back to me. They should bounce back to you immediately. I don't care if you get every single one wrong. The reason I required an email to take it is that way I will have a log. So if you need to prove to somebody that you actually watched this video and took the quiz, I can vouch for you. We're on the honor system here in Vermont. Not every state is, so just in case, that's why I did it that way. Anyhow, there it is. Thank you all again for watching, and stay safe out there.